One wrong decision in the boardroom can cost you everything: your personal assets, your reputation, even your financial future. In this video, I will explain boardroom liability, what Florida directors must know. And by the end of this video, you will learn how to protect yourself from personal liability, understand your fiduciary duties, and recognize the red flags that could land you in legal trouble. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've spent decades helping directors navigate the complex legal landscape of corporate governance, and today I'm sharing the critical information that could save your career. Let me tell you about a director I'll call Michael, successful businessman, respected in his community. He joined the board of a growing tech company in Tampa. 6 months later, he was personally named in a lawsuit seeking $5 million. His mistake? He trusted the CEO without asking the right questions. And this happens, guys, more often than you think. Many directors believe the corporation shields them from personal liability, but they're wrong. Florida law creates specific circumstances where that protection just disappears. Understanding these circumstances isn't just smart, it's essential. Let's start with your fiduciary duties. Now, as a director in Florida, you owe two primary duties to the corporation: the duty of care and the duty of loyalty. These aren't just legal jargon, they're your roadmap for making defensible decisions. You see, the duty of care requires you to be informed. You can't just show up to meetings and vote yes on everything. You need to ask questions, review documents, understand the business, and when a major decision comes before the board, you must dedicate enough time to fully understand it. This means reading the materials before the meeting, consulting experts when necessary, pushing back when something just doesn't make sense. I've seen directors get sued because they approved a major acquisition after just a 15-minute PowerPoint presentation. The deal went south, shareholders sued, and the directors claimed they relied on management. The court wasn't sympathetic. Reasonable inquiry matters. The duty of loyalty is equally critical. You must put the corporation's interests ahead of your own. It sounds simple until you're in the situation. Imagine you sit on the board of a company that's considering a supplier contract. You own a stake in one of the companies bidding for that contract. You have to disclose this. You actually probably need to recuse yourself from the vote. Failure to do this, that's a breach of your duty of loyalty. Florida allows interested director transactions, but only with full disclosure and fairness. The burden of proving fairness falls on you if challenged. That's a burden you don't want to carry. Now let's talk about the business judgment rule. This is your primary protection as a director. Florida courts generally won't second-guess your business decisions if you followed proper procedures. You must be informed, you must act in good faith, and you must believe your decision serves the corporation's best interests. But here's the catch. The business judgment rule is a presumption. It can be overcome. Shareholders can pierce through it by showing you didn't meet these requirements. That's when personal liability enters the picture. Now, if you're finding this information valuable, do me a favor and hit that like button below. It helps more directors discover this content, and subscribe to my channel for more insights on protecting your business interests right here in Florida. Let me tell you about the scenarios that create personal exposure. First up, there is fraud or intentional misconduct. The corporate veil provides zero protection here. If you knowingly participate in fraudulent activity, you're personally liable, period. Next is gross negligence. Gross negligence means you were recklessly indifferent to your duties. You ignored obvious red flags, you rubber-stamped decisions without any inquiry, and you skipped meetings consistently. This level of negligence can result in personal liability. And finally, the third one is illegal distributions. Florida law prohibits corporations from making distributions that would render the company insolvent. As a director, you're personally liable if you vote for making illegal distributions. You need to understand the company's financial position before approving any distribution. Directors often ask me about D&O insurance. Well, director and officer liability insurance is crucial here, but it's not a magic bullet, guys. These policies contain exclusions. They have limits. They often don't cover intentional wrongdoing. You need to understand what your policy covers before trouble starts. Read your D&O policy. Seriously. Most directors never do. They assume they're covered for everything. Then a claim comes in and they discover the policy excludes the exact conduct at issue. Don't be that guy. Don't let this be you. All right, let's discuss protecting yourself proactively. First, always review board materials in advance. You want to take notes, ask questions, and document your concerns. If you disagree with a decision, make sure the minutes reflect your opposition. Abstaining is sometimes better than voting yes on something questionable. Second, understand the company's financials. You don't need to be an accountant, but you need basic financial literacy. If you don't understand a financial statement, ask for help. Hire an expert if necessary. Ignorance is not a defense here. And third, watch for conflicts of interest. And they're everywhere. Your business partner wants to sell services to the company. Your spouse works for a competitor. Your child wants a job at the firm. Disclose everything. Over-disclose if you're unsure. Transparency absolutely protects you here. And fourth, be skeptical of management. Your job as a director includes oversight. You're not there to be a cheerleader or a yes man. Question assumptions. Verify important facts. Push for independent verification of critical information. Management should welcome this scrutiny. After all, this is your job. If they don't, that's going to be a red flag. Florida also has specific requirements for nonprofit directors. The standards are similar, but not identical. Nonprofit directors must ensure the organization operates within its charitable purpose. They must avoid private benefit issues, and they must comply with federal tax-exempt requirements. Violation of these rules can result in personal penalties from the IRS. And here's something many directors don't know. You can be personally liable for unpaid corporate taxes. Federal and Florida law allow tax authorities to pursue directors personally for unpaid taxes. This includes payroll taxes and sales taxes. If the company is struggling financially, make sure taxes are being paid. This should be a board-level oversight item. Let me give you a practical checklist. Before every board meeting, review all materials thoroughly. During meetings, ask probing questions. Don't accept just vague answers. And then after the meetings, ensure the minutes accurately reflect what happened. If you express concerns, make sure they're documented. And maintain independence from management. Your role is oversight, not cheerleading. Be willing to say no. Be willing to disagree. The best boards have a healthy debate. And you also want to stay educated on corporate governance trends. Laws do change. Best practices evolve. What was acceptable 10 years ago might expose you to liability today. Attend seminars, read updates, stay current. And finally, know when to resign. If the company is heading in a direction you can't support, resignation just might be your best option. And don't stay on a board where you're uncomfortable with the direction or management ignores your concerns. Your resignation should be in writing, and it should be clear, and it should be prompt. Remember Michael from the beginning of this video? He eventually settled that lawsuit, but it cost him 2 years of stress and significant legal fees. His D&O insurance covered most of it, but not all. He told me afterwards he wished he had asked more questions early on. He wished he had trusted his instincts when something just felt off. You have that opportunity now. Use it. Board service is an honor, but it's also a serious responsibility. Take it seriously. Protect yourself by fulfilling your duties. Ask questions. Stay informed, and act in good faith. If you found this video helpful, please like and subscribe to my channel. I regularly share insights on Florida business law that can protect you and your company. And your engagement helps me reach more people who need this information. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.